I think we're ready to get started again. Once again, the judge is late. We are now on to item number 8, which is the consideration and possible action on the following petitions and proposed orders for the exportation of low-level radioactive waste. The first one is item 8A, which is the application for exportation by NSSI, and I believe this will be a unique circumstance, but I will turn it over to Vice Chairman Salzman.
Well, the technical committee has received and reviewed an application for export permit from NSSI, Nuclear Sources and Services Incorporated out of Houston. In this case, it was dated December 29, 2014. And I'll sort of summarize, but in essence, they've indicated that the material, they've been requesting permits for a number of years to export materials. The materials are, I guess, probably would describe them as legacy materials that they've had for a number of years. There's some indication in their request that it's likely there could be some mixing of materials, that is, materials that were M-compact waste mixed with waste that is out of compact. And I believe that material has, when NSSI got that material, for whatever reason, it happened a number of years ago, so those materials may have been mixed together, but they did volume reduction on those materials, and now they're ready to export that waste. And sort of with that sort of condensed description, I think it would probably be beneficial if there were a representative of NSSI here to perhaps come up and discuss, provide the commission with a little more information about the waste.
Good morning.
Good morning. I'm Jay Poston with NSSI.
Is the microphone on?
Okay, I'm Jay Poston with NSSI. This material was exported to California back in 2011 and 2012. The last shipment was January 2012. Due to various issues they had there in California, the broker was not timely in their shipment of the material to Energy Solutions in Utah. They did send one shipment in December, which was accepted by Energy Solutions because we had a valid export permit for Texas at that time. They have another 39 drums they need to ship to Energy Solutions, but Energy Solutions needs an export permit from Texas, or is requesting an export permit from Texas to accept this second shipment. It is old waste, probably collected in 07, 08, well before I got with NSSI, so I don't know the detail of the history. So it would be very difficult to ascertain which drums are Texas, which drums are out of compact, and handle it in that manner. It is legacy waste, like John Salzman said, and it is somewhat of a unique situation that we're trying to deal with.
Jay, is it likely that there's been some perhaps commingling of materials in the drums? Because is it correct also that when NSSI got these materials from various waste generators that there was an attempt to consolidate and reduce the volume?
Certainly, yeah. It was a mixed waste when it was received, so it was processed to remove the wrecker constituents, and so it was most likely there was commingling at that time during that processing.
So is it also likely that if the materials were commingled during your waste processing, that what would be the remedy to try to uncommingle? Would you have to open up drums and try to sort through materials, or would that even be physically possible?
I don't think that would be physically possible. A lot of it's rubble, concrete rubble, some ash. It would be impossible to separate it out to what was compact and non-compact waste.
In the question that came to my mind, because of some internal discussions, how pressing is the need to ship these remaining 39 drums?
I don't know the answer to that question. Just they would like to get them off their site. They've been sitting there for 4 years now, so it's more of just managing their waste properly and getting it where it needs to be, getting it buried where it's safer.
And the reason I ask is I think that this issue may trigger some legal questions that we need to seek legal opinion about. There's also obviously a huge precedential value that a decision on this kind of export application may have, and so we want to be careful and well thought out in doing it. And so depending on what the recommendation of the technical committee is, we may not take any action on this item today and get some of these questions answered and then put it back on the agenda for the next meeting, which is at the end of May.
Okay.
I didn't know if that presented a practical problem to you guys or not.
Not for NSSI. As I said, the material was shipped to California back in October and August of 2011 and in January 2012, so it's sitting in California. We did have an export permit from Texas, which allowed some of the drums to go in December of last year. That expired before they could ship these other 39 drums. So, there's a precedent to have an export permit from Texas for this material.
So there was waste, the waste came from it was processed at your facility in Houston, then shipped to California?
Yeah, it came from all over the U.S., including Texas, was processed to remove the record constituents and then shipped to California for disposal.
So clearly you've indicated there are some of the waste was from outside of the state of Texas, but
That's correct.
I want to ensure some of the waste is known to be from the state of Texas, though. So
Correct.
Also,
But both are correct.
so those whatever of the waste that exists, whatever did come from Texas would in fact require an export permit to be sent outside the compact.
And we previously have approved an export permit, and nothing's really changed other than just the time.
Did we approve an export permit, or was it one of our predecessors?
That I don't know the answer.
I believe this commission has
Okay.
previously approved export permits. I seem to recall about a year ago-ish, but I can't remember the exact time frame.
For NSSI?
Yes.
Yeah, we have I'd have to look and see the dates and times, but I know we've done it.
Okay.
And we believe it was for this particular waste that he's talking about that's already gone to Utah?
To California.
Well, it went to California and then, but a shipment did make it to Utah and was
right.
accepted by Utah back in December of this year, and with the Texas export permit.
I mean, to the extent in what the commission would have approved before, that this issue was part of that decision, that I know, this has not been discussed. I think if this waste was part of that export petition approval, this issue did not come up and get discussed. That I do know.
And you refer to the issue of commingling, right, with other waste from other locations?
I do. And the issue, the commingling, and the issue the legacy issue as well. What waste could have been prior to having a facility open versus after having a facility opened.
Commissioner Sadick?
Do all these waste sites take Class B waste? You say Class A and B of all these different categories?
Yes,
They do.
I believe so, yes.
Okay, I just somewhere along the line kind of formed the impression that B and C comes here, but that A can go to other places, but
I do believe it
Mr.
is.
Sonic, I don't think we know that all sites take A and B.
Class A, I believe. I think it's possible that other sites, well, the site in in the Northwest Compact, Richland takes
Maybe.
Class A, B, and C. I know that factually, but the site in Utah, it's possible that they accept Class B sealed sources. I'm not sure if they accept other Class B waste, but it is possible. I know they had a provision in their license that would allow them, I believe, a one-year period to take sealed sources, which perhaps could have been Class A and Class B.
I would suggest that that to the extent that who takes Class A or B, but would be something that we should probably look into and see what the latest and greatest is. Because I do know that at some point Clive could take those sources, but I think that expired in December. So there's some more information that could probably be brought to bear to answer your question absolutely correctly, Commissioner Sadek.
I'm not suggesting that that is a reason to deny the export. I'm simply curious about it because just what I had understood to be the case.
And I want to make sure that we're clear on the two issues that I think are wrapped up in this. One is the commingling issue, but the other one is separate and distinct in that it's a legacy issue, that it was waste that was generated at a time before we had a compact facility here in the state of Texas. So those are two issues, but they're independent of one another. Would you agree with that, John?
I would agree, and I think it probably is important that we note for the record that the materials came to NSSI as waste. They weren't generated by NSSI. The materials
Right.
were shipped to them by waste generators as waste. They received those materials. They processed those materials. During that processing, some commingling took place, and then they drummed up the materials, shipped them to, I guess, another waste broker in California for shipment to a waste site, and that took place prior to the facility in Texas opening in April of 2012. The materials they received were in the 2007, 2008 timeframe, I believe, so long before the site in Texas opened up.
Yeah, they had some performance issues out in California that kept them from moving this as quick as they should have. As you know, the last shipment went January of 2012, and it's been sitting there for 3 years now, waiting to go.
Will this, in effect, kind of wipe the slate clean for you from the old
Very much
stuff?
so. It would wipe the slate clean for us and them both and get this taken care of and where it needs to be.
Any further questions? Well, I think the technical committee will have the right to make a motion as they see fit at this point, but I want to make sure that we had any and all questions answered. You say this will wipe the slate clean for you. Do we know if there's other legacy waste out there that from other processors or that may fall into the same category? Because that's an issue we probably need to consider.
There's none that I'm aware of.
I like the term legacy waste.
None that we've shipped to California and that they've sat on.
Any other questions? Thank you, Mr. Poston.
Thank you.
Any other discussion among the commission before we?
When you talk about the legal part of this, can I ask you if this legacy waste is kind of like the law, September 1st of some year, it becomes law, anything before that is not covered under the law? Am I thinking that way, or as the technical meeting said, well, we have a place now?
Judge, my concern from a legal standpoint is the lack of awareness on the part of the commission as to the extent of other legacy waste that may or may not exist in the state, and the concern is setting a precedent here. But if others know that it's not going to set a precedent, then there you are. But I'm not hearing that we necessarily know what other situations with other people, there may be legacy issues, and to that extent, one might want to wait until the next meeting to get information on that.
I think we have a comment from State Health Services.
Yes, I can address that to some extent because a lot of the licensees fall under my licenses. Currently, the state only has 2 waste processing licenses under TCEQ jurisdiction, which are NSSI and WCS, so those entities are taken care of. The other ones are manufacturers and distributors and service companies involved with sealed source disposal. And we do have several cases where sealed sources have been collected prior to the opening of the waste site and even many decades prior that are stored. And many of you may be aware of those situations. And so we've been working with those entities to make sure that they hopefully can segregate their in-state and out-of-state waste, but it is an ongoing issue. We have one company in particular that is, they're not represented here today, but they're getting ready to dispose of potentially 25,000 sources where the waste is commingled. The sources are commingled. And as the state health agency, I prefer that they not have to go through and segregate the sources because the amount of exposure that their workers might receive during that process. So I would hope that there'd be a way to commingle those sources. That said, those sources would be disposed of at the WCS site. So how we would handle the importation of the out-of-state generated sources versus the in-state generated sources is a further question that will undoubtedly come before the commission at a future meeting. This is the only case I know of where we have commingled waste that's destined for an out-of-state site. And I also wanted to say that the Utah site is Class A only. It's not B and C, or B or C. And even when they had that 1-year permit for sealed source disposal that was extended, it was for Class A sources only. Just to clarify that. Any questions for me?
Ray, you probably need to state your name for the record.
Ray Fleming, Department of State Health Services.
Judge, do you have a question?
Yeah, Ray, on the stuff you just talked about, that's all dry waste, right?
Yes.
And I'm gathering from Mr. Poston, he has some that's wet that WCS couldn't take care of. That's why they want to take it to
I
Tennessee and
would
burn it
assume
up.
it's all been solidified.
Jay Poston, NSSI. The waste we sent to California is all solid waste. It's not liquid. It's concrete, rubble, ash, soil, things like that.
So why couldn't WCS take that?
WCS could take that. Again, part of this waste was sent to Utah in December of last year under a Texas export permit. The profile and the path forward is set and done. And the only piece that's missing is the export permit from Texas. If we go back and then we have to ship it from California to Texas. We've got to restart the whole process of getting the profile approved by WCS and go through that whole process. So, it's one step away from being in the ground where it needs to be in Utah if we can get an export permit. Otherwise, we start over from scratch.
Sir, you submitted, I'm seeing in the letter here that yours was, the original export permit was requested on May 20th of 2010 and then approved on July 15th of 2010, and then it went through May 31st of 2011. So that's the export permit that you're referring to that Lee, I think we have some idea that we've seen before the commission here. Is that correct? Is this the same, are we all talking about the same export permit here, or do we know?
The answer is I do not know. I'd have to go back and look.
Now, is it possible that, and So the experts are saying that the Clive, Utah site is Class A only, and that this waste is in fact, or Class A and Class B. Is that correct?
It must be Class A to go to Clive. Again, we sent this to California 3 years ago, before I started working at NSSI, so I don't have a great deal of knowledge about the whole process, so I apologize for that. I've tried to learn as much as I could.
Now, I completely understand. I'm just looking over here, back here at the description of the waste. It describes it specifically as Class A and Class B, and maybe that's to the point the other commissioners were talking to. Are we in danger here of maybe approving an export of a type of waste to a location that we know is not capable of receiving it?
Yes.
I mean, it's certainly a possibility.
I think it's certainly a possibility.
And that's your description of the waste, I think, in this
I would
letter.
suggest you strike the Class B from that request if you approve it.
So you're confident that there isn't any Class B in there?
I'm very.
Or just-
Yeah,
Okay.
they wouldn't accept it if it was Class B.
So Ray, you're saying there's no Class B in there? No. Okay.
I think the other issue is the question related to, could the waste come back to Texas? I think the answer is it could. However, we create the reverse problem, which is if we bring it back to Texas to dispose of it at the Texas site, it's been stated some of that waste is out of compact. Now you have Texas waste mixed with out of compact waste. If they can't discern how much is what, it would all have to be treated as out of compact and pay the additional fees. So if we bring it back here, we just create the opposite problem.
You could put it on a barge that just kind of takes off.
New York State's barges.
Mr. Chairman, I'm going to suggest that perhaps we, in deference to NSSI, that we need to table this issue till our council has had a chance to perhaps obtain some more information with regard to setting a precedent for waste, whether it's imported or exported, and whether we have to issue an export permit. Mr. Krausen, does that sound reasonable to you?
Yes, it sounds reasonable to me. The applicant probably has a different view, and I don't know whether the health department would just as soon see it out of here. One might think about a motion that made it clear that no one should consider this a precedent of any kind until there's some more legal analysis done.
So you believe such a motion could be made that would make it clear that we're not setting a precedent with regard to imported or exported waste?
Yes.
Well, just one quick comment. And maybe I don't know that I'm necessarily comfortable with the idea that when we start talking about radioactive waste with respect to applications, whether it be because the class is listed wrong or it's administrative error or clerical error, I think we had something similar in the previous piece of paperwork, that we would be okay with just, and I don't think anybody here is, but just making an assumption that it's a clerical error that we can approve and then kind of retroactively fix. And the last question that I have is so if we were to approve this based on the idea that maybe there isn't any Class B in it, how would we go back in and then make sure that there wasn't any Class B in it? What mechanism do we have, or does, I mean, we're simply relying on the fact that at the Clive site in Utah, that they would see it come in, and then if there was any Class B in there, that they would prevent it from being accepted there?
My understanding is basically Clive would not accept anything that was Class B. They have to use their processes, whatever they may be, to make that determination. But the belief is that there's not any Class B. To the extent there is, Clive will just reject it. And then, I guess NSSI would be back to the drawing board on how to then go about disposing of that waste. Is that?
Well, okay, well then I guess I suppose my first motion, I guess my first one ever would be why, if the paperwork here is dated December 29th of 2014, and it clearly says that there may be Class B waste in there, why wouldn't we just require them, make a motion to deny it and reapply with the appropriate documentation on what kind of waste that they plan on moving or requesting in the export permit?
So that,
Or is that?
that can be
is
a
that-
motion, if
Okay.
that's what you want the motion to be. And then, is there a second to,
Are you making?
You know what, yeah, absolutely.
so there's a motion on the floor from Commissioner Weber
Yeah.
to deny?
Yeah, I would
the-
deny this based off of, I'm sorry to interrupt you, Chairman, but I think we ought to deny, I make a motion to deny based off the fact that they're essentially asking us to export Class B waste to a facility that we know does not approve Class B waste.
Is there a second to Commissioner Weber's motion?
Second.
Any questions or discussions?
I think probably the technical committee needs to discuss this further along with the council. So,
Mr. Poston?
I would like to point out it is Class A waste. And it's already been, the same waste stream has already been accepted at Clive as Class A waste. We're just trying to get the second shipment of the exact same waste into Clive, and they won't accept it because our previous export permit expired December 31st of 2014. And all we're looking for is an amendment, a new export permit to get the second half of this shipment into Clive, where it's already been accepted. They've been through our process knowledge. They reviewed the characterization of the waste and accepted it as Class A.
And I want to make sure I understand your motion. Obviously, the motion to deny the application in no way, and this may be a legal question for Mr. Krausen, in no way precludes them from making a future application about the same waste.
That would be my understanding. It would just simply be a denial of an application made on the 29th of December with a reapplication with the appropriate documentation.
Yes, you can, certainly that motion would work, and it's within our rules for them to reapply immediately with appropriate documentation. That would be not much different, I guess, in effect, from a motion to take no action with instruction for clarification.
So there's a motion and a second. Is there any further discussion or questions? Is there any further public comment?
Since the idea has been broached of this eventually winding up in Texas, I just want to ask one question. Since apparently nobody worked at NSSI when this waste initially arrived, what kind of chain of custody assurance do we have that none of the waste is of foreign origin?
Thank you for that comment. Obviously, I don't think any of us have an answer. Yes, sir.
I'm Kenneth Krieger, and I work for Radiation Technology. I'm also on the TRAB, but I'm not representing the TRAB. But I'm just kind of reiterating what Ray said, that there is a legacy issue, that there is a lot of sources that were collected before all this was kind of initiated. One of the issues that he brought up is about the commingling of waste. If it seems kind of counterintuitive, if I have a barrel of waste, I need to separate it and it's going to go into the hole right next to each other. There's going to be a lot of dose collected by many people trying to separate the waste. It's going to go into the same place right next to each other. I'm sure there's some way that you can get around that without including a lot of dose. But there is a significant legacy waste involved about sources and material collected before the rules and regulations that were promulgated through the disposal site and compact commission and all that stuff. So I just want to kind of reiterate, and this is some of the stuff that TRAB has talked about. We talked with Ray and TCEQ and trying to figure out a possible solution to where to get this stuff from temporary storage sites where it is now to actually being disposed of properly, safely in the hole.
At the point of commingling, wherever that may be, is there any type of documentation about what is being commingled in its source? Is there any way to backtrack and have some source of information that may help us understand, whether it be percentages or volumes or curies, as to what came from where?
Yes, all the people that have taken sources, with few exceptions, should have documentation where they came from. It's like if I have a drum that has 30 curies of cesium in it, I can pretty much tell you 15 came from end state or 15 came from out of compact. So again, the solution may be kind of go, I can have one drum that's commingled, but I'll say I'll pay for half of it as import waste and half of it as compact waste. But separating it seems to be a little bit more of an issue of dose received by the personnel trying to have to separate these things when they're going to go into the same hole in the ground.
And it becomes a health safety issue.
Yeah, most definitely. So I just want to iterate what Ray was talking about earlier, because
Mr. Chairman, I don't think, there's a motion and second on the floor, but I think that the thing that Ray and everybody's trying, and has always done within the nuclear family of this commission, is for us to, to do something. They've kind of got caught in a thing that they're just asking us to approve the rest of this to go. The problem is, as it stated before, the paperwork sometimes doesn't reflect what's is a problem. And I think that's a problem to them, because it says that it is Class B waste. We know that for years that the state of Utah has said no to Class B and C. So I think we could have a little 1-month moratorium. They go back and get their paperwork right, and I'll vote for his deal. But I think really we've already approved this, like NSSI has said, and we need to get it moved. We don't need to bring it back. We don't need to, it's got a place. We just need to get the paperwork done. And I really think, because as a judge, and a lawyer too, you have to take what is brought for you. We had 2 people said there's no B in it, but the paperwork says there's B in it. So we just need to get the paperwork right and then go on, I think. But I will vote for the motion.
My last point on that is, I completely agree with that. Really, it just comes down to a paperwork issue for me, and that was the heart of the motion itself. Certainly, we want to do what makes sense, in which, when we have these issues that come up with respect to legacy waste, and I would agree with the judge on that.
Any further comment? Any further public comment? All right, then we will call for a vote on the motion that is on the floor to deny the export application of NSSI, represented by item 8A on our agenda, with the understanding that a future application can be made with corrections to some of the things that have been noted. All in favor indicate so by saying aye.
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 All opposed, no. Motion passes. We will then move on to item 8B, the export application of bionomics on behalf of Texas A&M University Environmental Health and Safety Office. Vice Chairman Salzman.
The technical committee received a petition for export for low-level radioactive waste from Texas A&M University. The petition was made on behalf of Bionomics. That petition was actually dated April 7, 2015. And in this case, they're requesting to dispose of materials at the Energy Solutions facility. Their intention is the material is to be incinerated at the Oak Ridge, Tennessee facility, and then the ash would be sent to Energy Solutions in Clive, Utah. They're requesting up to 2,500 pounds of dry active waste and 30 gallons of oil. And in this case, the oil could not be sent to the WCS facility as it is. It's a liquid and couldn't be sent. And the DAW, by sending it for incineration and then disposal of the ash, you dramatically decrease the volume. I mean, it makes sense from that perspective to do that. So I'd be happy to answer any questions about the export permit.
Any questions of the technical committee on item 8B? Hearing none, we will entertain a motion.
I make a motion that we approve the export petition from Texas A&M University made on behalf of Texas A&M University through Bionomics for 2,500 pounds of dry active waste and 30 gallons of used oil they've requested a one-time period, but in this case, we typically make those export permits for a one-year period.
There's a motion. Is there a second?
Second.
There's a motion and a second. Is there any further discussion about item 8B? Any public comment on the Bionomics export petition? Hearing none, we'll call for a vote. All in favor of approving the Bionomics export petition on behalf of Texas A&M University Environmental Health and Safety Office, please indicate so by saying aye.
Aye.
All opposed, no. Motion passes on 8B. We'll now move on to 8C, which is another export petition from Bionomics on behalf of A&M Nuclear Science Center. Vice Chairman Salzman.
The technical committee received and has reviewed a petition for export of low-level radioactive waste made by Bionomics on behalf of the Texas A&M University Nuclear Science Center. And in this case, they've requested the ability to export 1,200 pounds of dry active waste, and similar to the previous export permit, the material would be shipped to Energy Solutions and incinerated, and then the ash would be sent to the Energy Solutions burial facility in Clive, Utah. Same reasoning, through the incineration, the waste volume is dramatically reduced from 1,200 pounds to probably a foot or two of ash at the most, perhaps less. So there's a dramatic volume reduction, and it seems to make sense that we would do that to conserve disposal space. I'd be happy to answer any questions about it. Oh, and I would note that the export request was signed April 2nd, 2015.
Any questions of Vice Chairman Salzman? We will entertain a motion then.
I make a motion that we approve the export petition from Bionomics on behalf of Texas A&M Nuclear Science Center for 1,200 pounds of DAW, low-level radioactive waste, for a one-year period.
There's a motion. Is there a second?
Second.
Motion and second. Any further discussion? Any public comment on items 8C? Hearing none, we will call for a vote on Vice Chairman Salzman's motion to approve item 8C, the export petition of Bionomics on behalf of A&M Nuclear Science Center. All in favor indicate by saying aye.
Aye.
All opposed, no. Item 8C passes as well. With that, we will move on to item number 9 on the agenda, which is the WCS report. Ms. Madru.
Yes, Betsy Madru, WCS. First, just wanted to publicly thank the commission for meeting in March despite the chilly weather and some travel schedules. We really appreciate that. And report to you that fiscal year to date, we've disposed of 18,852 cubic feet and 32,041 curies. Of that, 1,849 cubic feet is in compact and 806 curies was in compact. Other than that, I have no other matters to report to you, but would be happy to answer questions.
Say again the time frame.
Fiscal year to date, so September 1st to date.
Any other questions for Ms. Madru?
I just have a couple of quick ones, and you may not be able to answer them right now.
But I got Sherry.
Well, yeah, and Sherry probably can, but if she
Probably.
can't, perhaps she can just get them back to us through Lee at the appropriate time.
Okay.
I appreciate you putting this overall kind of capacity report for us together here. And I just have a couple of questions on that, and want to make a couple of statements just to make sure that the statements, first off, are correct. Maybe you can confirm or deny. And then I got one question about capacity specifically. So to date, your licensed volume is around 9 million cubic feet.
Yes, sir.
Is that correct? And to date, you've accepted 72,574 cubic feet.
Yes, sir.
That is 0.8% of your total capacity. So I've done the math on that. I think that's right. So over 2 years, we have essentially taken in 0.8% of what our volume capacity is, using the term capacity. So that's probably a couple of 100 years worth of disposal at that rate. Now, that rate may change over time, but for right now, that's the way I understand that. Overall total as of March 31st with respect to curies, total decayed activity that we've taken in is 190,462 curies of the licensed activity. That's 3,890,000 total curies. Does that sound correct? That's 4.8%. So the rate at which we are accepting curies with respect to our total license capacity is higher, but at the same time, based off of those current rates, we've got a substantial amount of capacity left. The only question that I have for you with respect to capacity, one concern that I have is, I would imagine when we start talking about cubic feet of waste that is taken in, you probably measure that. In other words, that is measured in cubic feet, correct? So this is maybe how much we take in. But obviously, when this thing gets put into our facility, it's probably going to take up a little bit more than that much cubic feet, depending on how it gets put into the facility, right? It goes into a larger cask, and the cask gets buried. So my question on capacity would be, and you may not be able to answer this now, of that 9 million cubic feet, what is the method that you use at WCS to, I mean, is that taking into account that this stuff is going in these huge concrete casks? And do you account for that? Or is that something that we're just going to have to account for later on? Now, right now, obviously, we don't have a capacity issue, but I'm just thinking, you know, as we move 10, 15 years down the road, are we going to run out of space because everything goes into a concrete cask that's got 50 times the cubic? Does that make sense, the volume, as what, you know, the actual waste does?
Sure, and I think I know the answer, but I'm going to wait, and I'll provide it back to y'all.
Okay.
Make sure I'm right.
Great.
Check with the experts.
Yeah, that'd be great. Thank
Sure.
you.
Yeah, you bet.
That's all I had. Thanks.
Okay.
Any other questions for Ms. Madru? Thank you very
All
much.
right, thank you.
With that, we'll move on to item number 10, which is the chairman's report. Obviously, I mentioned earlier that we are going to talk a little bit about the guidelines that we have drafted for future public comment, and I know some of you may have comments about that guideline, but before I do that, I wanted to mention a couple other things. Upcoming in April, I believe, is the Low-Level Waste Forum in Alexandria, Virginia. I know Ms. Ng is going to it. I don't think anyone else on the commission is. The judge has bowed out, but we will hopefully get a report back from Lee after she comes back, because those low-level waste forums are always very informative and usually educate us on a number of things. If nothing else, getting to interact with our sister compacts, that it's very important that we understand what each other are doing. On physical matters, we're happy to report there's nothing to report. The process with appropriations, I'm sure as some of you who follow the legislature know, the appropriations bills have been passed. I don't believe the conference committee has been appointed yet, but to date, nothing has happened that would impact our proposed budget. Previously in the process, we were approved for the amounts that we sought. We are still looking at those issues and trying to come up with bright ideas on how we fix some of the unique issues that face us, being a creature of federal statute that is funded by a state legislature. There is so many issues that I don't even know that I could name them all, but we are still looking to find, hopefully, an omnibus solution to some of those things. And if any of you have any bright ideas, please let us know. So with that, I will get to our guidelines for public comment that some of you probably have in your hand. Let me say a couple of general things about it, and then I'll talk about specifically some of the things that are included. The background and the reason for this is that we feel as though it's important to have some set of guidelines out there that allows anyone, whether it be people who regularly attend or people who attend for the first time, to understand how we will take public comment. To this point, we have had small enough meetings and limited public comment to where we kind of let people come as they saw fit, and first person to the podium got to speak, and it went however it went. We know that it's important to have a level of decorum, a level of order. These types of rules are pretty common at commissions and agencies, probably that most of you deal with in other areas. And so we thought it was important to put these guidelines down on paper, give everybody fair warning about them, and by all means take any comment you have about them. The goal of the guidelines is simply to give us a guideline to provide everybody the process, to make it orderly with things like speaker cards that I think you probably see in there, also to identify what's appropriate for public comment and what's not, to make sure people understand when they will be allowed in the agenda to comment, and also, ultimately, and you'll see this several times throughout, to provide a level of flexibility too. There clearly will be circumstances or issues where we need to suspend the enforcement of these guidelines. If a topic comes up and it becomes kind of a springboard for a much larger discussion, it's clear that we may not require speaker cards if we go down a path that requires or would be best served by additional public comment. And just because someone hasn't filled out a speaker card, we obviously would not enforce this guideline to preclude that kind of comment. Similarly, there may always be the idea that certain things will come up that the public and the commission may want to interact at a more active level on. For instance, while these guidelines clearly state that questioning of the commissioners or the questioning of other speakers isn't appropriate, there may be a time when that is appropriate. The commissioners will have that latitude, obviously, and ultimately it will be the chair who makes the decisions on that. But we will honor any of the commissioners' requests, obviously, if there needs to be more of a dialogue with speakers and/or questions posed, we will definitely bend the rules to make sure that's available. I say all that to then invite any of you who may have comments about these guidelines to come forward now and let us know what you think about them. Public comment's important to us. We wanted to make sure that at a minimum, we will always take public comment before we take action on things such as import applications and export applications, because public comment can very well influence the way a commission votes. So we value it, and we don't want in any way chill or deny people the right to public comment, but we do want it to be orderly. And with that, we will take your comments on the guidelines.
I want to take advantage of one of my last opportunities to stray from topic by saying thank you for your vote on 7A. There's a term on The Simpsons, when the kids don't want to say yes or no, they say meh, which is kind of in the middle. Well, thank you for voting meh on 7A. I'd also, while I'm being irrelevant, point out that it was the poet Thomas Gray, who as far as I know is not associated with Thomas Gray and Associates, who said, "Where ignorance is bliss, 'tis folly to be wise." Two overall comments on the rules. First, again with the limits, I've had enough history of public participation to know that every time it seems like the public is getting involved to a significant extent, that the first impulse of government is to slap some rules and restrictions on public input. It happened at the Austin City Council in the mid-90s. They took 6 months with the Blue Ribbon Commission to determine that there was really no changes to the rules that needed to be made. And they had more motivation for rules changes than you did. They had 800 people show up to a public hearing about the Barton Creek PUD, and the hearing ran for 13 hours. But it's part of a long history of Austin's encouragement of public participation. In the 60s, they had a civil rights ordinance that was before the city council. that took over a week, and took so long that one member of the council had a heart attack, went to the hospital, got out of the hospital, and came back, and the hearing was still going on. But let's hope that nothing like that happens. But if and when you have that level of public participation, I think it's time for you to come up with some rules. Just a couple of the items in this. Item E, speakers may not ask questions of each other or members of the commission. Oh, that wasn't what I actually meant to talk about. I was wanting to talk about the C, the public comments must relate to matters over which the commission has jurisdiction. I think you're kind of limiting the possibilities there for some significant public input. Like, I would like to encourage the commission to weigh in on the bill that's currently before the Texas legislature to limit contested case hearings. I think that this commission could make a difference in the consideration of that bill, but under these rules, I wouldn't be able to suggest that you do that. But I think it's important. There are important matters that maybe not currently be in your frame of consideration that you might want to weigh in on. Here's one that my experience with the city council has me really worried about. However, for convenience and efficiency, items may be grouped in such a way that public comment is received on a group of agenda items rather than on each item. This has been abused by the Austin City Council so many times to limit input. They came up with this stupid rule that they would take input from 30 minutes from the pro side and 30 minutes from the against side. As Karen Haddon has pointed out, many times there's more than two sides to an issue like that, and it really does limit the ability of people with an opinion that's a little bit outside of the yes or no column to come up with. I think it also has the effect of limiting public input. I'm also worried. Generally, comments of a public nature on a general nature by an individual or organization will be limited to 5 minutes. However, the chair may exercise discretion to extend time. This is one of the most abused things that I've seen in my experience with city government. I went to a planning commission hearing where people were limited to 3 minutes, and the developer, Gary Bradley, who wanted to ruin Barton Creek, rolled over the objections of the chair and spoke for 45 minutes and concluded with a barnyard epithet that I won't repeat, but he called the SOS ordinance BS. And it really worries me that WCS, for example, might be given an inordinate amount of time to respond to criticism that then the public would not have a chance to respond to. My final problem is with number 4, the final decision. The chair's decision with respect to any matter related to public comment is determinative. I really think that Henry Roberts and me would be more comfortable with the idea that this was a decision of the commission rather than the decision of the chair. And I want to make sure that the commission has the opportunity to appeal the decision of the chair, and you might want to consider that. Finally, I just urge you to err on the side of democracy and public participation. My biggest problem with this set of rules is that they're rules, they're a solution in search of a problem. You haven't had any problems. I haven't seen anybody led away in handcuffs. I haven't seen anybody shout down anybody else in a meeting of this commission. I understand the need to come up with a systematized rules. I'm just afraid that these rules may be too restrictive or might become too restrictive in the hands of a future commission. The one rule in it that I have absolutely no problem with is a sign-up card. And in fact, I think you'll find from the sign-up sheet that there are apparently only 3 people at this meeting today. So I would really think that maybe a sign-up, maybe all of the action you need to take, and to make sure that you're not solving problems that haven't arisen. Thank you.
Thank you very much for your comments. Any other public comment on these new guidelines? For those of you that didn't get a copy, I'd encourage you to grab on the way out. It does, like Robert said, it does put time limits that can be changed in the discretion of the chair, and there's other things in there that are very specific, with the most immediate one probably being that speaker cards will be required now. So that will be the way we hopefully organize things. If there's any other public if there's any other comment to these new guidelines, we encourage you to email them to the commission. We still would like all the input of the public as much as possible. The final thing I'll say about it is, I believe this is an organic document that can be varied as we go through and as we see how things work. Because they're a guideline and it is something that by our bylaws is left at the discretion of the chair, we can alter this document as we see fit, whether it be based on comments you give or comments from the commission. So if these change, obviously they will be published to all of you and on our website as quickly as possible. But these will be the guidelines going forward, subject to whatever revision that we make. And we will start using these guidelines starting in our next meeting in May. And with that, that concludes the chairman's report, and we'll turn it over to Ms. Ng for item 11, the ED report.
Comment. I think the commission needs to have this on the agenda to approve this, and I would make that motion, not a motion, but have it on the May docket so we can approve it on the May docket of these, how we're going to do business. And I will defer to our attorneys, but I think Commissioner's Court or City Council or things that are in the government code as a public meeting, most of those, I know Robert, have had the entity adopt those rules on the agenda instead of just taking comment and saying that. That's just my comment.
I would just comment, Judge, that the rules of decorum are almost always the matter of the determination of the chair, and the chair could have.
In my Commissioner's Court, they're not.
I understand, but the chair could have, certainly could have been exercising these same rules right along, just as a matter of maintaining decorum, and these are written down, and
So you're saying that legally we don't have to do that?
that's what I'm saying is a legal matter, yes, sir.
Well, I just want to make sure that, everybody reads the law different, and so I just didn't want to get us into some, and I totally agree with everything on here, and I agree with Robert sometimes that I think the chair is going to have let somebody talk for longer than they may or whatever, but I had a district judge one time, and you've been in courts that sometimes you just let the record run. I don't really want to do that, but at the same time, I don't want to be, as our legislature and every other, as Robert says, because he's been, we had 3 minutes to talk about a big bill on taxes the other day, and we had 3 minutes. Each person got up there, and it's like, I said in my commentary to the other judges, I said, this is quantity, not quality. And Senator Betancourt actually stayed in the hearing, which the last time this got brought up to the cities and counties, the guy that was running the bill left. He wasn't even in the room. So I really think this is a big thing, and that's why I said in my comments today. But I totally agree with you about cards and decorum and all that. I'm not totally against it. I just thought that we needed to formally put that out there. So if our lawyer says we don't, then that's fine too.
We appreciate the comments, and I will make this commitment that when the time's appropriate, obviously, time limits will not be enforced when the circumstances dictate it, and that's the reason that we wanted to make sure that there was the flexibility in these rules to allow for that. The only time I'll limit comment is when it's yours, Judge, so. With that, we'll move on to item number 11, the Executive Director's Report from Ms. Ng.
All I have to say is I will be going to low-level forum, and I look forward to generating a report and getting it out to folks about what the forum, sister compacts, et cetera, talk about. The only other thing I have to mention is, as many of you know, we have the development of our standard operating procedures and policies manual well underway. Ms. Melinda Lecomte, our contractor on that, is in the audience, and many of you met her through the break. We're probably about halfway through that process, and I think we're going to have a really good process that comes out of it, not only in that it'll outline our procedures when we need the outline in case somebody else has to pick up that book and make a meeting happen. But in addition, as going through our policies that particularly our procedures, Ms. Lecomte has noticed, as you mentioned earlier today, Chairman, that there are some procedural problems that arise from being a federal compact that is beholden to a state agency in order to get something done as merely getting reimbursed, heaven forbid trying to buy a computer or something else. And so she is, as part of this document, putting together a list of observations where she is noting that these are issues that might be something that need to be discussed further by the members of this commission and that our attorney may need to look at. And I think that'll be a very interesting piece of this, in addition to solving the problem of not having our operations written down. So you'll be hearing more about that from me, but that's well underway, and we're enjoying working with Ms. LeCompton getting this advanced. That concludes my report for today. If you have any questions, please let me know.
Commissioner Saudick?
This kind of out of the blue and probably wouldn't qualify in your, but, I'm curious if you could just find out, I think you probably can find out on a phone call faster than I can, how many nukes are operating, how many nukes have been shut down, throughout the country, just kind of the whole status of the industry, and also how many are either being built or are planned to be built, new ones. I mean, people assume when you're on a body like this, people kind of come up to you and say, oh, by the way, da-da-da-da-da. I can never answer those questions. If you wouldn't mind finding out, I'd appreciate it. Maybe you know, right?
I do not know.
Okay.
But I can find out. We can absolutely find that out. And
We may have an answer already.
I just so happen to make a copy of Nuclear News with me.
There we go. I left mine at home.
To best of my knowledge, and people help me if I get the numbers wrong, used to be 104 power plants in the U.S., 5 of them shut down. There's 99 currently running. There's some of them that are in the operation phase, but they're not operating due to maintenance down, et cetera. And there's 5 being built right now. There's 2 brand-new AP1000s in Georgia, 2 AP1000s in South Carolina, and 1 in Tennessee, I believe, which is an old style, which was started in mid-'80s, was about 50% finished, stopped, and they're starting to build on it now. So that's about sort of most of the answers for what he was asking about.
Do you just, yeah, thanks. That answers my questions. Do you know, are there others that are, I mean, when Vermont Yankee shut down, it was a while coming. I mean, they announced it a year before and all that sort of thing. Are there others that are about to shut down that you're aware of?
There are a few that are undergoing license renewal, but usually the license renewals are done many, many years in the future. Like I just read that there's one going to shut down in 2022, but they're going to have their license renewal started now. I do not know of any that is immediately going to shut down for any reason. There are some that have a 50-50 chance of not starting back up from where they are now, because of like the same thing that happened in California. They were down for an outage or a repair, and things happened to a place where they just didn't feel like it was worth coming back up and running. So there are some that are like in the operating classification of operating, but they're not running right now. They're down for maintenance. They're down for other kind of miscellaneous things. And so some of them may or may not come back online, depending upon the license applications. Some of them have to are going underneath review by the NRC about what's the word? When they go for a license amendment, they have to have a public comment, and so then they have actions against the plant to say, hey, we don't think you should apply or to give this amendment due to this, and so there's a big hearing and public comment. So there's some that are in limbo, but.
Thanks a lot.
You were safer when you stayed with Power Magazine. There aren't any that are on the verge of shutting down. We're in a limbo like that. There are, of course, some that are down for refueling, but none who's returned to operations in any immediate peril. There is one that's scheduled to shut in 2020 as a result of a commitment they made. That's over.
There is a chance that a number of Exelon plants in the Midwest are going to shut down. They're currently in negotiation with various states, including Illinois. They say that because of low natural gas prices, they may not be able to continue to run the plants without financial assistance from the state. The second thing I would say, though, is that www.nrc.gov has the daily reactor status report, which will tell you which plants are down, which is another piece of information that you probably need on a regular basis. Sometimes that percentage runs as high as a third. But the third thing that I wanted to tell you is that there was a news story last week stressing that the application for plants 3 and 4 at the South Texas nuclear power plant is still in the NRC license project. And even though NRG has committed to putting no more money into the project, they are still pursuing the license for those 2 additional plants.
Thank you.
Thank you for that detour.
Would it be of assistance for me to put all this in writing somehow? And
I think I've got it.
Okay.
But, thanks.
With that, we'll move on to item 12, which is discussion and possible change of dates and locations of our future meetings in 15 and 16. As you know, we try to keep a year's worth of meetings out there. A couple of changes to note. We had at one point talked about having our May meeting in Andrews, and we are not going to do that now. So the May meeting for sure will be in Austin, and will it be here?
it'll be in the Capitol.
Okay. We have not determined a location yet for our July 9th meeting. That is something that remains to be decided, but it's likely that it will be here. And then we're now thinking that our August meeting, which is August 20th, will be in Andrews. So that's fair warning for everyone that wants to go. They'll need to make plans to go to Andrews. We will once again try to meet at some point in Vermont. We were discussing it earlier, and we hope maybe that could be the October meeting, which is October 1st. But that is still in the early planning stages, so we will know more about that hopefully at future meetings. Other than that, I don't believe any of the dates need to change. That is always subject to discussion and circumstances beyond our control. But otherwise, the next three meetings will be May 28th, July 9th, and August 20th. And after that, we get into the fall meetings of October 1st and October 12th.
November 12th.
I'm sorry, November 12th. Any questions about meeting dates or locations?
Let me repeat this back just to make sure that I heard it correctly, since I want to make sure we get whatever hotel's in the right place. The next meeting, as we all know, will be Austin, Texas. We will plan on the July 9th meeting also being in Austin, Texas. The August 20th meeting will be in Andrews. We will be working with the commissioners to have the October 1st meeting in Vermont. And then after that, there'll be the November 12th, January 14th, February 25th, April 17th, and May 19th meetings, location not yet determined. Did I understand all that correctly?
Yes, that's my understanding.
Okay.
And we will always be exploring the idea. Chairman Wilson made a point that was always very good, that sometimes we need to get out of Austin too and to other locales in Texas. So we will always probably be looking for the possibility to go to other cities to have our show on the road, so to speak. Any other questions about dates or places? All right, well, then with that, we will entertain a motion to adjourn. Is there a second?
Second.
All in favor? Aye. Thank you all very much.
Thank you for
Made it by
getting us
12:20.
out of here, yeah.